Hello, and welcome to the Arbitration Conversation. So, this is actually a special episode because it's Cyber Week. So, we are celebrating Cyber Week. It's something we do with the National Center for Technology and Dispute Resolution, and it's free and open to the public. And this interview is going to be included as part of the offerings during Cyber Week 2020. And so with us today, we have a real treat. We have really an entrepreneur in the area of dispute resolution. We have Hafez Virjee, and he actually runs Delos, which is an online international dispute resolution company. And I'm excited to have him here to hear about what he's seen in arbitration, how that has really changed in the wake of COVID, and how perhaps online arbitration has become more the norm instead of the exception. But we'll ask him about that. So thank you so much. I'm really delighted to have you here, Hafez.
Thank you. Thank you. No, the pleasure is shared. And knowing your stature in the field and your all of the work you've done on tech and dispute resolution, it's an honor for me.
No, truly, the honor is mine. One thing we were talking about before we started, I'd like to share with the audience because I think it's a really cool story. So how did you come up with the name Delos?
Well, the premise of this institution is time and cost efficiency in arbitration. And we wanted a name that captured that. And for some of you, you'll know that at least up until the end of the 50s, so I guess prior to the New York Convention, arbitration was put forward as a time and cost-effective method of resolving disputes. As far as we could tell, one of the oldest structured methods of dispute resolution that used arbitration was the Athenian League, and the neutral forum was the island of Delos. So we thought that was a fitting name for what we're trying to achieve.
Absolutely. And what brought you to actually develop Delos and to sort of take the plunge in this area of international dispute resolution?
Really, client feedback. So at the time I was practicing in France, and French lawyers tend to have their own clients because they're considered self-employed. So I had feedback from my clients at my firm. I had feedback from some of my own clients, which were much smaller. And everyone was saying the same thing. Your arbitration thing is all very well, but on smaller disputes, it doesn't work very well, if at all. And what they really meant was, in terms of time and cost, it doesn't match with business cycles. Until the day when a friend of mine said, but wait a minute, you're in arbitration, can you do something about it? And at that point you're thinking, okay, I can either pick up the challenge or look the other way. And so got together with a group of colleagues, and here we are several years later.
And how have you sort of changed the model to match the business model, as you say?
Well, I think the starting point was to look at every step of an arbitration, consider whether it could be done more efficiently, as well as whether everyone's interests were aligned. And once you look at things systematically, once you look at things systematically, you can achieve a lot of efficiency. I think where we went further is you'll find that a lot of institutional statistics look at the time elapsed from the constitutional tribunal onwards. We looked at the whole process starting from the contract formation stage.
That makes sense, absolutely. Well, and I guess, I'll talk about more adjustment of the process. How have you seen the process change and adjust with COVID?
So definitely a big shift to online. One of the things that we found interesting to observe was March, April, May, you had a succession of communications from all the leading institutions saying, please try and file your cases online. Here's an email address. Please don't send us paper versions. And at that point, we stepped back and we looked at our rules, and we took note of what we'd done a long time ago, which was by default, our rules say, please send your request for arbitration by email. There is no process for us to receive it by paper. And I think there are two considerations there. One is technology supporting being operational in this remote working environment. And second, it's also coherent with trying to benefit the environment.
Oh, 100%. That's a really good point that often is not emphasized, but I like that. The problem is, how do you deal with technological differences? One of the major challenges when we talk about OARB, or online arbitration, and having online hearings, is just making sure everyone has sufficient access to and comfort with technology. How have you, as a company, or have you been able to adjust and assist the digital divide?
That's a very good point. Actually, if you allow me to digress one moment, just to clarify, we're a French law association rather than a company. So our status is one of non-profit making. What we've done is, and this may be, at one level, it may feel like a letdown, but just bear with me. We've looked at what our users, meaning the arbitration community and companies, are comfortable with, what they're fluent with, and we worked around that. Email, everybody can do. Cloud storage, everybody's familiar with. Zoom today, or Teams, everybody's familiar with. So the existing components that you can easily bring together without taking the risk of designing something new, which is going to be costly, which is going to have its limitations and flaws, and where people are going to have an extra learning curve. And so, and part of the thinking there is we've all made, meaning all the institutions, council, arbitrators, clients themselves, they all have existing investments in different tech products. Let's leverage that rather than add a layer to it.
Oh, I see what you mean. And I think, well, but still, I'm sure there are going to be circumstances where you just decide that perhaps a hearing, it cannot proceed online. Have you run into that, where there's certain circumstances where the parties are just not going to be able to arbitrate online?
No, effectively, I mean, you're right. And then you just have to find a solution that that can work for everyone. I think maybe as a perhaps slightly roundabout way to answer that question, but you'll see what I'm getting to. One of the distinctive features of our rules is we tell arbitrators up front, this is how long you're going to have to submit your draft award. It doesn't have to be a final award, but it's an award, which means that then when they're looking at the calendar, they're not just looking at how much time does each side want for their pleadings and when will we plan a hearing. They're also looking at, okay, how much time do I have for drafting my award, but also what logistical issues might arise. And so then tracking that backwards, if you get the sense up front that you got difficult parties or that parties will want to meet in person or may not be comfortable with meeting online, then you build that into your thinking of the case right from the start.
Absolutely. Well, and I'm sure what it also means is, for your arbitrators, they need to have sufficient training so that they're adept at handling these situations.
Yes, and to your point, I'd say we're quite proactive in accompanying our arbitrators so that they in turn can be proactive in managing their cases.
Well, and so, and that gets to the question of, how do you recruit your arbitrators and decide on who the arbitrators are?
So we don't have a list system. What we do is we say, for each case, the best suited arbitrator, unless parties have agreed on a designation, or if it's a three-member tribunal, then each one can nominate their own arbitrator. But I think there is truth to the expression, this may be a French expression, far from eyes, far from sight, far from mind.
Oh, we have the same one, out of sight, out of mind. We have the
That's the
same.
one. And so what we've done is we've created a database that people can register their interest in, to say, if a case comes up and I'm suitable, then please keep me in mind to serve as an arbitrator, because then we don't lose sight of people. So that's how we manage the process.
That's exciting. So what do you see happening, going forward? So sort of as you think about 2021 and what arbitration is going to look like for your company after the pandemic? Let's say we finally get a vaccine. Do you think we're going to all go back to face and in person and paper copies?
It's a big question. So in June 2020, with a couple of colleagues, we ran a survey that was with Gary Bourne and Annalise Day QC. And what were the ask of the survey was for people to tell us how they'd engaged with remote hearings, what their views were on what the level of comfort was, what their views were on remote hearings going forward, and a number of related questions. And we've already published some of our findings, but we've got a lot more to pull out. But really what's coming out of that is, yes, remote hearings are part of the toolbox. They're here to stay. There seems to be a preference for people, from practitioners, to want to go back to physical hearings, but not in all cases. In cases where the stakes are greater, the complexity and the number of witnesses and people around the table is higher, whereas smaller hearings, shorter hearings, and are likelier to switch to remote hearings, to a remote format, I mean. And the other shift is CMCs or case management conferences or pre-hearing conferences or meetings used to be run by phone. More and more, I think they'll be run this way by Zoom and video.
Yeah, I think those are definitely, your findings don't surprise me, just in that I've heard pretty much the same thing from the American Arbitration Association here. So it seems to make a lot of sense from what we're hearing. I do think though that the culture is changing, just because, we have grandmas and grandpas who are Zooming with their grandchildren, and families that are having holidays via Zoom. And I do think it's changing the culture and sort of comfort with video. Um, I think my question to you as well, and probably you have heard from clients, is, this whole idea of paying for a lawyer and paying for individuals to travel, especially when you're talking about international travel. Now that video is available, I think a lot of clients are sort of not very keen on spending that additional money. I don't know what your thoughts are.
It's a fair point. I think looking back to my days as a counsel now, I run Delos and I sit as arbitrator, but for a long time I was practicing as counsel. And I'd say one thing that's very difficult to replicate by video is some of the fact finding you do with potential witnesses and with the clients, especially when you're trying to get a feel for someone's testimony, whether it's their testimony or whether it's reconstructed. Sometimes just being there is nothing beats that.
Yeah, I do understand that. I used to represent parties in arbitration, and there is a certain amount of credibility testing that happens in person that's awfully hard on video. Yes, I will have to join you in that. Well, this has been a really fun conversation. I think we had some really interesting points, and I think it's great to sort of put the finger on the pulse of what is happening in international dispute resolution and international arbitration in particular. I'm just delighted that you took the time with us today. Thank you so much.
It's my pleasure. Thank you for having me.